A very common question that I get from celebrities and famous personalities is whether their name itself can be trademarked in India. Quite recently, a book author asked me whether her pen name can be copyrighted. I had to explain to her that a copyright only vests in a literary work itself, such as the content of a book. There is no copyright on the author's name or even on the title of the book. I then went on to explain to her that although there is no chance that she could get her pen name copyrighted, she may still be able to get her name trademarked if certain conditions are met. So this made me think, why not do this week's episode on trademarking of names? Oh, and by the way, today's episode is the 10th episode of my video series on intellectual property and technology law, a show that I started 3 months ago and release weekly episodes on. I have even converted this series into a YouTube channel to share my knowledge and resources from the domain of IP and tech law. So, why would one claim exclusive rights over the use of their name? The answer is fairly simple. Most businesses are named after their founders. Over time, if these businesses are successful, their names gain tremendous value. Customers connect these names with these businesses themselves. Now, interestingly, the old statute on trademarks in India, the Trade and Merchandise Act of 1958, did not allow the registration of a surname as a trademark. However, the present law on trademarks in India, being the Trademark Act of 1999, is silent on this. On the other hand, there is a particular provision under the current Trademarks Act, Section 35, which says that the proprietor of a registered trademark does not have the right to interfere with another person's bona fide or honest use of his or her own name or the name of his or her own place of business. So, plain reading of Section 35 would indicate that just because a person has registered a certain name as a trademark, they cannot stop another person who has that same name from using it for their business. However, in actual implementation, courts have frequently held that where a mark has acquired distinctiveness, it serves as an exception to Section 35. In simple words, where a name has become so well known or embedded in the public mind that people associate a particular brand or business with that name, others can be prevented from using that name for their businesses. This would be irrespective of the fact that such other person may be using this very own surname for their own business, right? Even if they're using their own surname, it would not matter. And more importantly, the word bona fide in Section 35 is very important. Section 35, which says that a person cannot be stopped from using their own name for their own business, even by the proprietor of a registered trademark for that name, specifically mentions that a person's use of their own name has to be bona fide or in good faith. Courts have felt that bona fide here means with good intent, without any intention of encashing upon the goodwill or reputation of another's name. So you see, this is where people who are using their own name for their own business maybe stop for doing that. As most of the time, if someone else's prominent brand name already has that name, the person who is even simply using their own name would likely be benefiting from the larger, more prominent brand name, right? And in fact, when trademark cases go to court, parties often show their sales figures to courts to indicate that they are a large, prominent brand with a massive reputation and goodwill, which the public at large knows about. So courts always give preference to a trademark which is prior, distinct, and known to the public at large. In short, a brand. So now let me explain to you how it could practically work out if you go down to the trademarks registry and try to get your own surname registered as a trademark for any business, say a line of clothing or a jewelry brand. Chances are that you would simply get rejected. That's right. Your application for getting your own surname registered as a trademark for your very own business would get rejected unless you're able to show unless you're able to show the registry that your name is distinct and that's it and it is clearly distinguished from other names in the same business. And it can't just be any generic common name which one can easily confuse with others in that same business. So somebody with the name Agarwal would really struggle here, as Agarwals are present in almost every line of business, and it would be hard to get such a name registered as a trademark in the registry. Now, since we're talking about trademarking of names, there's one aspect which we just cannot miss out upon. I'm talking about the most expensive names out there, the ones which are the biggest of companies are willing to pay lakhs and crores to be endorsed by. I'm talking about celebrity names. Many celebrities in India, such as Sunny Leone, Amitabh Bachchan, or the famous chef Sanjeev Kapoor, have had their names registered as trademarks. They're allowed to do so in classes where goods and services are being sold under brands by their name. Right? So there are different classes of trademarks. So if goods and services are being sold under their name in a certain particular class, then they can have trademark of their own name registered in that class in the trademarks registry. However, there's also a tendency of defensive registrations of trademarks adopted by some celebrities. This means registration of marks in classes which the name is not being used in to actually sell any goods or services, right? And they do this to prevent their name from being misused at all. Such practices are not considered appropriate in the eyes of the law, right? The law does not consider it right to register your trademark in a class where you're actually not selling goods or services in. That would be considered hoarding of a trademark or wrongful marketing of a trademark. And for example, the famous King Khan has registered his name in all 45 classes of goods and services of the trademarks registry. Something like that is frowned upon by the law. See you, friends, colleagues, and IP law enthusiasts watching this show. That brings me to the end of this episode. Stay tuned for more exciting episodes of the Utsav Mukherjee IP and Tech Law Show. Hope you have a great day. Cheers.